going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. I've got a good one. I hope you guys are having a great day so far. Happy Wednesday? It's Wednesday, right? Yeah, it's Wednesday. Happy Wednesday. Ah, I've got a kind of a long one. We are in Judge Spalding's courtroom in Georgia, I believe. I think he's Georgia. Pretty sure it's Georgia. And we have a pro se defendant who not only filed a ton of motions, he's fired attorneys, he had a public defender, he had a retained defense attorney. Both of them withdrew, slash, he fired them. And then he yelled at court staff. So we're in court today for a contempt hearing. Oh, this is a good one. I'm not going to lie to you. This is a little bit of a long one. The fireworks happen at the end. And this is a 2 hour and 15 hearing, 2 hour and 15-minute hearing. We're probably going to make this 2 nights. It's really good, but we got to watch the whole thing for you to understand it. I wanted to clip out all the slow parts, but you really can't. You can't if you want to understand it. You know, you don't understand the end of the movie unless you watch the parts that lead up to it. But the end is absolutely fireworks. But like I said, it's a long hearing, so we're gonna have to get through this. But it's good. It's good throughout. We got a pro se getting yelled at by the judge. Prosecutors fed up with this guy. It's a good one through and through. But like I said, the very end is absolutely the best. And yeah, we might not do that tonight. It might be a 2-part hearing. Anyways, that's what we're playing tonight. Anyways, hopefully you guys had a great day so far. Let's get into it. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Many plates spinning and some Led Zeppelin lyrics in there, and none of it got worked out. All right, Mr. Stringer, come on up to the table here.
Oh yeah, one more thing. I stretch this. So the way that Judge Spalding does his courtroom is he does, the videos on one screen, his image is on the right for anyone that joins via Zoom. But so because no one joined via Zoom, I just stretched it. So it's going to be a little blurry. I can't really help that, but I did my best. Let's go.
Here with whatever it is you need. Actually, just bring all your stuff with you, please.
Yes, sir.
And Terry, this will be a transcript.
Okay. No, sounds good.
You ready, Ms. Sexton?
I am not.
Mr. Stringer, raise your right hand.
Yes. Yes, Your Honor.
Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
Okay, take your hand down, state your full name for me.
Christopher Stringer.
Mr. Stringer, you are here today on the court's notice of indirect criminal contempt, as well as a bond modification or bond status review would be the way I would call it, on 25 SR 0282. I'm going to place on the record why this is here, and I also need to put a few things on the record from you. One of which is that, do you understand that there are 2 hearings being simultaneously conducted based off of the same evidence? Yes or no?
Just for clarification, you said the bond and the contempt?
That's correct.
Yes, Your Honor.
Do you understand that the standard of proof for contempt is the same as any other criminal jury trial for guilt or innocence, which is proof beyond a reasonable doubt?
Yes, Your Honor.
Do you understand that the standard for a bond status review is the much lower standard, which is preponderance of the evidence? Or if these were the scales of justice, it would be 50.1%. Do you understand that that's the standard of proof on the bond modification?
No, Your Honor. Can you clarify that a little bit more?
So there are multiple standards of proof. One is beyond a reasonable doubt. You're with me on that one, correct?
Yes, sir.
Beyond a reason to doubt.
Yes, sir.
The other one is what's called preponderance of the evidence. The way I would explain preponderance of the evidence, which is the same standard as the civil case, which is you take the scales of justice, and for the record, I'm holding my two hands up like they're the scales of justice. Beyond a reasonable doubt would be this, and I'm holding one hand up high and one hand down low, way low, and I'm now going back to preponderance of the evidence, and I'm just going to move my right hand a little bit up and my left hand a little bit down so that you'll see one is slightly higher than the other, and the other's slightly lower than the other. That's preponderance of the evidence. That's the standard of proof for me to decide a bond status matter. Do you understand that now?
Yes, Your Honor.
Okay. So that's what we're doing today is two hearings at the same time. On the criminal contempt matter, you understand that you have the right to have an attorney represent you.
Yes, Your Honor.
And you are here representing yourself.
Yes, Your Honor.
And we have been over this ad nauseum
No, yes.
about
yes,
your
sir.
rights to be represented.
Yes, Your Honor.
And you have hired and fired multiple attorneys. Is that a fair statement for me to say?
Yes, Your Honor.
Okay, because you had the public defender's office and you fired them in open court, correct?
Yes, Your Honor.
And then you hired one of the local premier defense attorneys, Mr. Singleton's office, and then you fired them after they filed their motions.
Yes, Your Honor.
Okay, so there was a pause there that I'm trying to unpack in my head, which is that you paused when I said you fired multiple attorneys because I just thought of that as a very easy factual statement, and I'm a little concerned about that pause. Do you need to unpack that, or is there something I'm missing that caused that pause?
Yes, Your Honor. And it's just, I'm not quite here to address that. I'd rather address, the situation at hand.
What you want to address or not is of no concern to me.
Okay, yes, Your Honor.
We're here to address what I want to address. So I'm sorry that is something you don't like, but I honestly am not concerned about that.
Yes, Your Honor.
So only one of us gets to run this hearing, and
Yes,
it's
Your
not
Honor.
going to be you. It's
Yes,
going to
Your
be me.
Yes, Your Honor.
So we're going to address what I want to address. Do you need to address anything else about your hiring and firing of multiple law offices? Because I don't want to hear later that you didn't understand about your rights to represent yourself versus your right to be represented by an attorney. So this is your opportunity to address that if you have any questions or concerns.
It's a difficult process. I'm trying to figure this whole process out myself. It's.
Well, how about
that's it.
this? I'll just ask some very specific questions and that'll get what I need on the record.
Yes, Your Honor.
You understand you have the right to have an attorney represent you at this hearing.
Yes, Your Honor.
You are sitting at this table by yourself. There's no one there with you.
Yes, Your Honor.
You are currently unrepresented. Is that true?
Yes, Your Honor.
And you are currently wishing to represent yourself at this hearing. Is that a true statement?
Yes, Your Honor.
Okay. Well, then I have what I need. And is it your intention to continue representing yourself as we move forward in this case, or do you intend to try to retain additional counsel?
I represent myself, Your Honor.
Okay. Well, then that's what I need to consider. So I'm going to put that it is my obligation and responsibility to review on the record at this contempt hearing that it is a indirect criminal contempt hearing where you have the right to have an attorney represent you.
Yes, Your Honor.
And you have elected to represent yourself and move forward. And I'm going to find, because we've already done this several times, that you are knowingly, voluntarily, and intelligently waiving your right to representation and demanding to represent yourself. Is that a fair statement, or do you have any objections to that ruling?
No, Your Honor.
Okay, then we're good to go on that. The maximum punishment I can give you for this indirect contempt hearing is 20 days to serve in the Spalding County Jail and or a fine. Do you understand that that is the maximum possible sentence I can give you on an indirect criminal contempt case?
Yes, Your Honor.
Do you understand that as a bond modification with the much lower standard, I can actually make a lot of changes to that, including the revocation of your bond, but I don't have to do that beyond a reasonable doubt? Do you understand that the standard is lower?
Yes, Your Honor.
Do you have any questions you want to ask me about this criminal contempt hearing and this bond modification hearing about anything to do with that before we step in?
I had kind of wrote everything down so I could be quick and to the point for you.
Okay.
Is that okay?
Yes?
Did you want me to go ahead and read it now, or?
I don't know what you're about to do.
Yeah, look at this binder. I wrote all of my thoughts down and put it into a 500-page binder. Is it okay if I read that to you right now, Judge? Yeah, I told you we're in for a good hearing. Lisa, thank you so much for the 11 months. I appreciate it. Thank you so much, Lisa. Good to see you this evening.
And so I'm trying to figure that out.
Yes, Your Honor. I'm just saying as we proceed, I just have, as I'm making my statement and going ahead with this, I try to write everything down so it's to the point, so I'm not kind of going back and forth to make it easier for you. And I just want to ask permission to reference that if necessary.
You may open your folder and reference whatever it is that you need to reference to feel confident that you are appropriately tracking and responding to this moment.
Yes,
Now, the state did not file this motion for contempt. I did.
Yes, Your Honor.
And I did because it was brought to my attention that you, while represented by counsel, appeared at the clerk's office and attempted to file a thumb drive. Thumb drives are not proper for filing in the clerk's office. Now, I got just enough information. You need to know I am not fully briefed on all of this.
Yes, Your Honor.
What I know about this case is what I'm telling you,
Yes, Your Honor.
which is that there was a back and forth with you and Ms. Evans, who is present here in the courtroom,
Yes, Your Honor.
about your attempt to file this thumb drive with something on it. And that you were told, I believe, that such a filing of such a thing is not proper with the clerk's office. You were also trying to file a piece of paper, and we are, of course, trying to steer towards, when we've been steering towards e-filing since 2016.
Yes, Your Honor.
And from my understanding, you are arguing with the clerk or disagreeing with the clerk or whatever you want to characterize it as, and that your result, your decision of that moment was to write something out and abandon the file, the flash drive, and that document in the clerk's office saying you filed it, and that they came out to try to get you before you left to try to give it back, and that you refused to take it. That took up significant bandwidth in the clerk's office, disrupted the orderly operations of the state court clerk's office, which is an extension of this court. When I was notified of it, I filed this. And I'm just letting you know, I just don't want you to assume that I know things I don't. I've given you what I know. Now, I have more information now that you filed it, which is, it's very clear to me when I read your response that you have some sort of recording that you made of this interaction with the clerk's office. Did I understand correctly that you have some sort of audio or video recording?
I have it on record, Your Honor. Yes, sir.
Okay. I'm going to ask my question again.
Yes, sir.
Am I correct that you have an audio video recording of this interaction that you had with the clerk's office?
No, sir. I have a picture that I had taken of the actual filing that I had made, because I said I was going to write it out. And then I just had the transcript, the audio of the interaction.
So when you just said, no, you don't, and I said, do you have an audio or video? The correct answer would be that you have an audio recording of the interaction. Is that correct or not?
Yes, Your Honor. Is
Okay.
what I'm saying.
Because you made it very clear in your response, because I read your response. You filed it, you wanted me to read it, and I read it.
Yes, Your Honor.
And it was very clear to me that you have some sort of recording of this. And you're telling me it's not a video recording, it's an audio recording.
Yes, Your Honor.
Okay. All right. Have you provided a copy of that audio to anyone, or have you held it within your own file?
I was talking to Miss Sexton. She was saying that she can't receive it via USB. I said I could send it to her via email, but we wanted to wait on your approval of or when we were going to do that.
Okay.
Can I comment?
Yes. And just
You're jumping ahead, Jedi. You're jumping ahead. You're jumping ahead. We'll get there. We will. We will. We will.
1 second. So, because I'm going to come over to you in just a second, let you fill all this in. Okay. All right, Mr. Stringer, is there any other housekeeping you want to address with me before we jump into the facts? Again, the facts I gave you were just so that you can understand my knowledge basis as we get started. Do you have anything else we want to address before we jump in, before I hear from Ms. Sexton, and then we jump into the actual hearing itself?
I guess I'll make those statements when it's my turn.
Yes.
Yes, sir.
Again, this is a housekeeping moment.
Yes, Your Honor.
All right, Ms. Sexton, the floor is yours.
So I'm not exactly familiar with the way this hearing should go. Can I make an opening statement?
Yes, yeah, we're going to get to all that. This is all just the housekeeping for me to understand what, for me to put on the record, the context of how we got here, for me to address his rights to have an attorney, to explain to him what the maximum, minimum punishments are, and to make certain that the record is clear as to what his risk exposure is here. In just a second, we're going to pivot to the actual hearing itself, and we'll start with opening statements.
So I'd like a little housekeeping.
Yes, that's what we're doing. Go ahead.
I'd like to ask Mr. Stringer at this time, if at any time on today's date that he has been recording either audio or visual in this courtroom, prior to this courtroom, my discussion with him prior to the hearing.
No, ma'am.
Okay, so you currently have no audio and or visual recording device going on at this time?
No, ma'am.
All right. And just so you know, we are live streaming this to YouTube. So obviously, if you decide you want to look at it later, you can look at it later. And if you want to get a copy of the transcript from Ms. Terry, you may purchase a transcript from Ms. Terry, but you are not allowed to record without permission of the court in the courtroom at any time ever, whether or not I'm on the bench.
Yes,
So
sir.
do you understand that when you're in public spaces, just to be really clear,
Yes, sir.
when you're in public spaces, you are allowed to record.
Yes, sir.
Whether or not it's good form is irrelevant. It's whether or not it's legal or proper.
Yes, sir.
And the answer is when you're standing in a public space in the courthouse, you may do that. But when you're in the courtroom inside these four walls, whether I'm on the bench or not,
Yes, sir.
you are never allowed to do that without my permission.
Totally understood. Your
And I
Honor.
would very likely give you that permission if you ask it at the right time, in the right way, with the right equipment. That's not going to be disruptive. But I'm also going to tell you, Ms. Terry is here taking this down, and I live stream it to the internet. So I'm just letting you know that that's what we generally always do.
I didn't, could I speak, Your Honor? I didn't know that you streamed it to YouTube.
Yeah, Spalding County State Court.
If I go on YouTube, can I see the other,
I don't know what I do and what I don't.
Yeah, you can jump on YouTube and watch everything on my channel. Cool with Colin. Let's go. Selfless plug. Yep. Do I feel bad about it? Not at all.
We've had, in the transition, I have had some significant technical difficulties, and I've had several sessions that got missed.
yes, sir.
So was yours missed? I have no idea.
Yes, sir.
You are welcome to go hunt for it.
Yes, sir.
So just go look on the days you're there. It's up on the date and it's listed by date.
Yes, sir.
So, but I do try to put every court date up there, but we did have some significant technical difficulties as we got started.
Totally
All
understand.
right, Ms. Sexton, anything else?
No, I would just like to clarify, that there were two issues here, and one is, about tapes, and I just want to make sure that we're clear on this. There is an issue regarding a tape, which was a recording device, which occurred, from a police apprehension arrest. That's not what we're talking about today when I'm referencing this next little bit of conversation. Prior to this, I approached Mr. Stringer and basically said, I did not subpoena your recording. However, if we want to streamline this, if you have a recording of this and you want to show it to the court and you show it to me, we can do this ahead of the hearing so we can just figure out what's going on. And Mr. Stringer said no,
No,
which he,
Don't. put your poker face on, and you better keep it on.
Yes, Your Honor.
Don't do that again.
Yes, Your Honor.
Go ahead.
Which he is entitled to do.
I love that. I absolutely love that. No, 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 no. Stop, 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 stop. We're gonna be adults here. Take a deep breath. We're not interrupting. I love it. Good job, Judge.
I was not mandating, I was simply asking to streamline, because this whole case has been an example of inefficiencies as far as trying to handle a case. So it was simply my request, can I look at the tape? He has a laptop. I didn't ask for it to be emailed to me, to be sent to me. Can I see it on?
All right. This is a contempt hearing. This really has nothing to do with the charges he's actually facing. This has everything to do with how he's treated the court staff. So he walked into the courthouse after firing his attorneys, tried to file a thumb drive for, he wanted to show a video, like to file a video as, for his discovery to give to the prosecutor. The court clerk said no, and he started berating them, yelled at them, and then started recording them on his phone. That's what we're here for. So this has very little to do with the actual underlying case. I can't even tell you what the case is about. This is all about this dude firing his attorneys, trying to do things on his own, failing miserably, yelling at people, and recording them. That's why we're here.
Your laptop, just so we can figure out what it is that you're trying to say. And that request was, he did not want to do that, which is fine, but I want to make it clear that it had nothing to do with the security, because I asked him if he brought his laptop. which
Okay.
he brought. So that was not the issue. I don't want that to be misrepresented, Your Honor.
Okay. All right. I think that concludes our housekeeping. We ready to jump
Yes.
in? All right, Mr. Stringer, anything else before we jump in?
Yeah, I just want to put on the record when, to my understanding, what you were saying when you had approached me was that, that she had an understanding that there might have been a recording and that, if we wanted to take a look beforehand, if we can do that. And, I was trying to figure out if it was, if I needed to send it to her via email or what we were trying to figure out. But I was trying to make it, I want to make it clear that, I was trying to say, if you want to see it beforehand, yes, you can.
Okay, so you're offering to make it available?
Yes, Your Honor.
And how would you share it? Dropbox, Google Link? What's your preferred method of service?
Whatever is easiest for her. Last time I sent her the video via Gmail, but
Okay.
whatever.
Well, if you got a Gmail folder that the state already has access to, drop it in there. And even if it's after the hearing, drop it in there so that they can have a copy of it. Because if you do present it at the hearing today, they'll need a copy.
Yes, Your Honor.
Okay. All right. Anything else?
That is it, Your Honor.
All right. I have misplaced my legal pad. I'm going to go grab that real quick, and then we'll jump in with Ms. Sexton's opening statement.
We lost the judge. Why do the chairs at the defense and the prosecutor table look more comfortable than the chair the judge has? We need to fix that, right? We need to fix that. Oh, he's back.
Okay. Ms. Sexton, the floor is yours.
Your Honor, I'd like to place some context
All right. The opening
On-
statement's
on
all
this-
yours.
on this situation. From the beginning of this case, the court has offered courtesy and grace to the defendant. The defendant appeared extremely late at a court date of 2/1/25, and a bench warrant was issued. When he explained that he had been stuck in traffic in Atlanta, the bench warrant was lifted. Subsequent to that, even though it was late in the game, the judge reviewing the court transcript, and it was you, Your Honor, because there are two judges involved. It was you and Judge Esri on one of the other hearings. You offered for him to go see the public defendant. And even though it was a little late in the game, you suggested that he go see the public defendant. There was some confusion about an obstruction charge and merging charges, and you suggested that he see the public defender. As you are aware, he then hired the public defender. As you are aware, Mr. Charles's credentials are pristine and are full of integrity. And because later in the game, Mr. Charles consented to a continuance, which was going to be automatic by the court anyway, as each side was allowed a continuance. Mr. Stringer in open court insisted on being heard after Judge Esri had granted the continuance. And that was Judge Esri gave him time to speak. And again, it was a long protracted discussion about what was going on with this case. And even though it was not properly filed and it was not properly done, Judge Esri granted a speedy trial. The format of the filing of the speedy trial was incorrect. However, he was kind enough to grant, again, another courtesy that the court was given. Second of all, well, I'm not sure what number we're on, but then again, when there was a request for a speedy trial, even though Your Honor could have insisted that that not be adhered to because it was not properly filed, again, you extended the courtesy of giving him a speedy trial because Judge Esri had done so from the bench. This is where all niceties on the defendant's side have lapsed. The state has been accused of withholding evidence. The state has been accused of lying about the availability of their witnesses. And the state has been accused of all kinds of misconduct regarding discovery, so on and so forth. The state has expended a great deal of time.
Hey, what's up, Midgie? Good to see you tonight. Good to see you. Thank you for joining us. Real quick, Tara, thank you so much for the 5 gifted memberships. I appreciate it. Welcome to the 5 new members. Thank you so much, Tara. You are awesome.
Investigating these situations, trying to answer these situations, and rectify these situations. It should also be noted, and this is in a court transcript, that the whole reason we're here today is because the defendant wanted to file a thumb drive with the court and had already acknowledged that the thumb drive had been given to the state by his attorney, George, at the Singleton firm. So I'm not sure why this was absolutely urgent and requiring a filing, which cannot be done anyway, and why the defendant, who claims in his filings that his actions were in good faith, were not willful, and were based on confusion. The state will prove that that is not what happened in this case. It should also be noted that while it is not illegal to record an interaction that occurs in public, it is bad form, especially when the other people do not realize they're being recorded. And just because somebody does not raise their voice, and just because somebody does not get loud, does not mean that they are not disruptive, that they are not rude, and that they are acting in a way which is demanded by the court. There was a court order that Carly was obeying as the filing clerk, and in a contempt charge, if a court order is willfully ignored, then that's the basis for a contempt charge, among many other bases. But there was an e-filing order filed on 7/6/2018 regarding the fact that all cases in criminal court, which is the court in question right now, there were other cases that also had to be e-filed, but we're talking about a criminal case right now, that had to be e-filed. So it's the state's position that there was a valid order, which Carly was aware of as an employee of the court, that she had to obey, and that she was simply telling the defendant that she could not accept it per the court order. There were other reasons why she was told she could not accept it. Another being that we had just had a very serious security risk, and no flash drives were being accepted as being entered into evidence. And thirdly, there was a genuine issue regarding his representation, as he had not, the defense counsel had not been properly withdrawn from the case. All of these things were issues that fall under contempt, but the state plans on proving that it was a violation of the court's order, it was willful, and despite what the defendant has argued, that this was not a good faith attempt or a situation of confusion.
All right, thank you. All right, Mr. Stringer, floor is yours for opening statement.
Yes, Your Honor. Your Honor, I hope you don't mind if I, move back a little bit as far as,
Sure, just let John move the mic so Terry can keep up with you. And again, you're welcome to sit or stand. You're welcome to go to the podium. It's important to me that you be as comfortable as you can be in the courtroom while you're making your presentation.
yes, Your Honor. And
Just
also,
stay near the mic.
I'll stand just to, show respect, Your Honor.
No problem.
I want to start off by saying, I have written down, like I said before, I have written down everything that I'd like to say. I was going to talk about just what's here at hand, but Ms. Sexton has, taken it a little bit farther back. So I would love to appreciate, I'd love to answer or respond to the issues that she had brought up. As you know, this is a case that began in 2024 on December 15th. Ever since then, I haven't needed it. This is not a city that I live in. I live all the way up in Duluth. It takes me an hour and a half to 2 hours to get here every single time. Yes, I was late one time. That is because I have to Uber here. And the Uber, I left at 6:30 in the morning, and I still didn't get here until after 9, which was what made me significantly late because, as we know, Atlanta does get traffic and gets very heavy traffic from time to time. And so I was considerably late, but I also did call ahead to the courthouse to let them know that I was going to be late. Also stating from that, I've had multiple, knowing that and how far it is, it's about a $150 round trip is what I pay every single time I'm here. As we know, I've been here multiple times, and I was late one time, so I'm here showing that, I show up and to present myself and respect your time as well. What she had also mentioned was, moving from that point, saying, I've had situations that have been extended to me. As far as, the speedy trial, and then also your recognition of the speedy trial as well. That came from when I met in front of the judge on the 16th of March, that we spoke about, and I told him what I was going to file, and that I was asking him to grant the speedy trial, and he accepted that request. As far as filing, I told him I would file that afterwards, so it was done properly, and so that it is following the orders. From as far as actually being attentive to the court's needs, I have also acknowledged that, I have had filings that have been declined, just because I have said in filing it via the web or online that, I was going to hand it in person, and that has been denied because I did file it online instead of handing it in person. So, I've been respectful of the court, heard all the court's, decisions and rules, and I've abided by those. And, when those were denied, it was, I didn't make a big deal of it. They were denied. Okay. And we moved on. And as far as when we're going to talk about the Jukes firm and how they were able to represent me. Me and Mr. Charles had a conversation beforehand where he wanted me to accept the plea that they were offering. This is all before. This is all after he said he had received the evidence of the video that they had obtained. When they obtained the evidence, when I asked him if they had the video, he said yes. He said, I need to plea. I said, I haven't seen the video as yet. He said, it doesn't matter. You need a plea. Yeah, you won't make it on the stand. I said, I would, love to see it. I also told him that I did not want the continuance because of the matter at hand with my custody case. With the custody case, not having a license definitely affects you. And, as I was researching and, seeing all the evidence, I thought my case was valid. Now, on that, I had Mr. Charles compel for discovery. When he compelled for discovery, Ms. Sexton and her team, what they provided was the physical documents of everything that had happened, as far as the statements, the witnesses, the statements from each officer, where it happened, what happened, and the things of that sort. When I received that, I let Mr. Charles know, hey, I had my ALS hearing, which is why my license is suspended and has been suspended since July of last year. That, they showed me a video. So I know that they have a video. Can we ask to see if we can get the video? To which he responded, we have to get the video. To which Ms. Sexton and her team had provided to them a video. And this video was, when I had finally got the chance to see it, this video, the only thing the video had showed was the last car approaching at the very end, pretty much when I was already being taken away, and it showed nothing of what had happened. And so, I told Mr. Charles, hey, number one, you compelled for discovery, and first they said that that's all that they had. Told them that they had more, so they asked for more, and then they finally came back and provided that video. after that, I from then,
Remember at the beginning when I said this hearing is about the contempt of court, it's not about the underlying charge. He's talking about the underlying charge. Judge Spalding's letting him talk as much as he wants, maybe because he's representing himself. I don't know. Most judges would have cut him off, said, "Hey, we're not here for that today. You're speaking in deaf ears." But no, judge is letting him just get all the record he wants to get all that record, every single bit of that record. It's all yours right
I had asked Mr. Charles to, begin to dismiss the case because that's all they had, and it didn't show what was necessary to provide the necessary things needed for the things that they were charging me for. From that instance, moving forward, I had asked him, I want to get this done. I have custody. Let's get this done right away. I don't want this to drag out. Let's get this done. From there, I showed up to court on time, and I was discussing with one of the other attorneys the options, and they said, here's some things that they're providing. Here's what they're asking, and I was explaining that, hey, I have proof that that goes against what they're saying. And at that point, as I was talking to her, Mr. Charles came out and said, we're getting a continuance. And I said, Mr. Charles, I can't do a continuance. This is going to affect other things. And so at that point, I let him know that I did not want the continuance. Unfortunately, when he stood up in front of the judge, when the judge had called my name, he still asked for the continuance. At that point, asserting my rights, I let him know that I do not want the continuance. At that point, he turned to me and he said, I am your attorney. What I say goes, and you're getting the continuance. At that point, since he wasn't doing he wasn't asserting what I was asking him, and he was pretty much doing what he wanted, I said, Your Honor, I'm sorry, I'd rather represent myself than go with the continuance that can further hinder my obligations, especially trying to be there and provide for my daughter in ways that she needs. So moving forward, although she says that, I've been given all the niceties and things of that nature, we also know that moving forward, that I moved forward with the Singleton firm. I let them know that, hey, I want to do this the right way. Hopefully we can get this done quickly and easy. I said, hey, I handed it to him. I said, I'm hoping this is going to be very, very easy and the easiest case that you guys have. When we spoke, they had agreed, and they were doing the right thing. They had also filed for a continuance. At that point, we talked when Miss Hudson was in here. I talked to her. I said, "Hey, Miss Hudson, I do not want the continuance. I cannot do the continuance." She said, "Okay," and that's when she took away the continuance. At that appointment, or at that hearing, I'm sorry. Although Miss Sexton and her team had already been granted continuance, and you said everyone is granted a continuance, at least one. She asked for another continuance as well, and the continuance was for an officer that she said was on FMLA leave, to which I took it upon myself just to verify and make sure that everything was fine. Just because in the past she said that she had given me all the evidence that she had before, and I was able to obtain another one. So I wanted to do my due diligence and just confirm with the open records that the officer that she stated was on leave, because I knew that there was 4 things that she had to prove in order to get the continuance, which was the witness is truly material, and their testimony cannot be obtained from any other source. That she did her due diligence to use that and to secure the witness attendance. The witness will actually be available at the continue date, and the facts that that he could not testify, that his I'm sorry, the facts that he would testify to are not provable through other witnesses. We're not we're said to be we're said to be true. So upon my due diligence, I've asked in the open records if he was on FMLA leave. They stated that he was not, and that he was on active duty. And I said, is he on active duty and currently working? And they said, yes, he is. So this is just another rock in the road that has further delayed everything, the entire case of what has been happening. So
That is a great argument. Really good argument. Good on you for finding that information out. Not the time or the place. I don't know why the judge hasn't stopped him yet. He's been going on for what, 10, 15 minutes now? I'm just sitting back, scrolling on my phone at this point. And come on, dude, wrap it up. We got more hearing to get to. You're here for contempt, not to defend your case.
as far as niceties, I have showed up. I have, except for one time, I have been on time, regardless of it costing me $150 at least round trip, just to make sure that I am here every single time. I've gone out of my way to hire attorneys to try to make this quicker and easier so we could get done with this. And unfortunately, when I presented that information to Ms. Hudson, I asked her just to simply put it on the record. Not even the fact that she had to challenge the that she had to challenge the continuance, but at least put it on the record. She refused to do that. I felt it was at least my right to have that on the record, knowing that I had asked for right to speedy trial, and and to show that I am, on my part, I am doing everything to get this trial done. Yet Ms. Sexton and her team have been allowed multiple continuances, more than what I was told is that the court normally allows. Upon that, I was this this recent incident came up from, yes, Miss Hudson and her team, the Singleton firm, had filed motions on my behalf. I did not know that they had filed the video via however they had filed, or so you say that they have filed the video with you. I knew I wanted to get that on the record because at the trial, at one of the hearings we had, you yourself, Your Honor, said that if you found it, and you listed what the Brady violation was, and if you found that was true, that you would dismiss the case. So I wanted to make sure that you had that in your hand, so that you did have that ability to do so. As Unfortunately, Ms. Hudson had told me that the last date to file was the end of April. Knowing that it was the last day and communication had been delayed, I wanted to make sure that everything that could be filed was filed. So that is why me and I try to have a pretty in-depth conversation with Ms. Hudson to have the fact that even if it wasn't to challenge the motion, at least the FMLA open records conflict was at least put on the record. Knowing that that was the last day, I knew I had to at least make sure it was done. Although being in a rock and a hard place, you know, the whole reason I was able to get the video in the first place was, unfortunately, I had to represent myself in the custody case, to which is where I was able to get the video that I had of the body cam that Miss Sexton and her team did not provide, and said that they did not have. So I, having represented myself before, I felt wanting to make sure I got everything on the record that I could do that. Now, when it comes to this case, like I said, I am doing everything I can to stay within the what is demanded of the court, and I wanted to make sure that I was doing everything in a way that I could respect the court as well. Knowing that that was the last day, I went ahead and filed the motions that I needed to at least get that on the record. And that is in that filing, I did go ahead and put in there, that was filed, that was e-filed, saying that I would drop off the video the next day in person. And that's kind of what brings me to where I am right now. So that way we could kind of get moving along. Obviously, I have filed a written response to the contempt and plead not guilty. I have an audio recording of the May interaction that directly contradicts the allegations in the contempt notice, and I am requesting permission to present that recording as Defendant's Exhibit 1.
Okay. Anything else?
Oh my God! Please say no. Please say nothing else. I let that go. I'm sorry, guys. I should have fast forwarded that at least 2 times just to get through it a lot faster. That would have cut down this video. Man, I don't remember him talking for this long. He talked 99% of what he said has nothing to do with him being held in contempt. The very last thing he said right there. Oh yeah, by the way, all this about the underlying case. Oh, I've got video or I've got audio proof that I shouldn't be held in contempt. That's all you need to say, man. That's it. Thank you. Thank you for your dissertation.
Did you want me to go ahead and present it, or?
So do you have a laptop or something?
I could, it's on my phone. I also have it on my laptop, whichever one's easier.
You need, so it's not your turn. We're
Yes,
gonna
sir.
do this, but what we're gonna do first is Ms. Sexton gets to go first because the burden's on her to prove beyond a reasonable doubt that you're guilty of the contempt violation.
Yes, sir.
While she's doing that, I want you to get your laptop out
Yes, sir.
because I don't have the ability to do it from your phone, but if your laptop has an HDMI port, then we can plug it in and push it up to the wall.
Yes, sir.
Okay. All right. Go ahead and do that while she's proceeding. All right, Ms. Sexton, the floor is yours to begin evidence.
The state calls Carly Evans to the stand.
All right. So for record purposes, Ms. Evans, as the clerk responsible for state court operations, is seated at the clerk's table. She's moving over to the witness seat. And if you'll swear her in.
Can you give me 1 second?
Sure. Yeah, absolutely.
I'm so sorry.
Well, he's doing that too. So,
Yeah.
all right.
Yeah, it's old fashioned court, right? When your opening statement takes 90% of the entire court hearing. Yeah, that's how,
And while we're off record,
that's how it used to work, right? Right? No, that's not the case. Yeah, I didn't think so. I was trying. I was.
when you get that, when you have it pulled up on your screen, tell me,
Yes, sir.
because I'm going to try to push it up to the wall as a test run.
Yes, Your Honor. Give me a second. I think I could send it from my phone to my
Yeah, it's
laptop,
fine.
and I'll get there quicker, but my computer's down here.
It's going to be a minute before we get to that.
Yeah, you got time. The prosecutor is about to question the person you yelled at. Remember her? She's sitting on the stand. This is fun. This is fun. uh, he's oblivious to what's going on. He really is.
Thank you, Your Honor.
Great, Terry. Okay. All right. So, Mr. Stringer, you just keep working on that. I will say when you do have it pulled up on your screen, just raise your hand and just let me know, and that way I know kind of where you're at. So, Ms. Sexton, the floor is yours if you'll swear your witness. Probably.
Okay. All right.
Ms. Evans, will you raise your right hand, please? Do you promise the testimony that you give today is the whole truth and nothing but the truth to help you God?
Yes.
Carly, can you please, for the court, give us your full name and spell your last name?
It's Carly Allen Evans, Evans.
Can you tell the court your job description or your job title?
I work in the clerk's office, but my title is Deputy Clerk 2 of State Court Criminal.
Can you describe to me some of your duties in court and then some of your duties in the clerk's office?
Inside of court is rescheduling court dates, stamping in orders that the judge files, stamping in orders that the attorney file, stamping in final dispositions, making sure hearings are correct. As far as outside of the courtroom, there's a list, a lengthy list, but accepting e-filings, sending out calendars, sending out notices to defendants, phone calls, checking emails from either the team, solicitor's office, or attorneys.
Would you say that as a general rule, Monday through Friday, you're pretty busy?
Yes, very.
All right. And can you describe to the court how long you've worked in the clerk's office?
I've been in the clerk's office 3 years this month, but officially in the state court division about 1.5 years.
And are you aware of the policies and procedures of the clerk's office?
Yes.
And can you describe to me the policy and procedures regarding criminal filings?
As far as criminal filings, everything is mandatory e-file as of the order that you referenced from 2018. Whether it's an order, an entry of appearance, waiver of arraignment, anything that the attorney or someone pro se wants to file, it is mandatory e-file. So it's all electronic.
Do you have any understanding as to why that's done?
I'm not sure.
All right, that's a fair answer.
I'm going to present to you a copy of this order signed by Judge Spafford, dated 7/6/2018.
I will say she should have an understanding of why it's done. No, so they already stated they had a security risk. I'm guessing somebody allowed a thumb drive that compromised the courtroom security. So they stopped allowing people to turn in thumb drives. Very, I mean, they shouldn't have allowed it in the first place, but it makes sense. So now you got to go through a third party system that will scan your virtual whatever, and you can upload them that way. Yeah, that's how courts should work if they don't have their own security system. Yeah, she didn't know. Okay, but defendant decided to make a big old thing about it, and we're here for contempt. Again, we are an hour into this. This hearing only need to be 15 minutes. I blame both the pro se defendant for taking 30 minutes for his dissertation of an opening, and the prosecutor for calling the why do we need the court secretary here? You could have had a written statement. That's it. That's all we needed. Anyways, let's go.
And the defendant, if you'll give me 1 second, we're going to give you a copy of that, sir.
I have that order.
Do you have that order?
Yes, ma'am.
So
Okay.
you're aware of the order?
Okay.
Wait. Can I clarify which the notice of indirect?
No, that's not the order. Let me make sure I'm giving it to you because I want you to have it.
Omnibus order? Just one minute.
Yeah, I realized that right when I said it. He can't cross-examine that. Yeah, I still don't know why she's a witness, though.
So Carly, I'm sorry. A little off track. Did I give you a copy of the order?
Yes.
Okay. And in essence, is that the order that you've complied with the entire time that you've been in the clerk's office?
Yes.
And in essence, that says that everything has to be e-filed.
Yes.
And would it surprise you to know that one of the reasons for doing that would be that the court handles over 7,600 cases last year and that e-filing makes it a lot easier?
Right. That's correct.
Can you imagine 7,600 people showing up behind the little glass there, trying to hand you pieces of paper and recording devices?
It would
Recordings.
probably make it a lot more difficult.
Okay. Are you also aware of an email that came from the county saying that under no circumstances could flash drives or anything external be accepted?
Yes.
And are you aware of why that occurred?
I believe it was Kyria that sent all of the Spalding County employees an email, just stating that there was some sort of breach, that we were not able to accept flash drives, USBs, anything until further notice.
And that occurred prior to Mr. Stringer coming in. That was dated 4/15. Is that correct?
That's correct.
And Mr. Stringer appeared on 5/1
I believe it was April, yes, 5/1.
or April 30th, 5/1 or April 30th. So there was a clear mandate that anything that had to be filed would be filed e-filed. And that under no circumstances would you accept a flash drive for filing.
Yes, that's correct.
Okay. Can you just describe to me about how many people, plus or minus, are in the clerk's office at any given time?
Daily, I would say, obviously it depends on the day, if there's a holiday, but roughly between 50 to 100 people that come through our office daily.
Okay, how many employees are in the office?
I believe it's 17 right now.
Okay. Can you describe, using your own words, what occurred with your transaction when Mr. Stringer attempted to come to the clerk's office and make a filing?
Yes. So on May 1st, Mr. Stringer entered into our office and initially tried to hand me a flash drive. And my initial response was it evidence that he was trying to serve on the solicitor's office because we don't accept flash drives in our office? And he said no. And I asked him to have a seat and to give me a second because I was going to have to go ask some questions. Because at that point, our Superior Court Clerk, Ms. Brooks, was not in office. Our Chief Deputy Clerk, Sherry Smith, was not in office. So my automatic instinct was to come to Judge Thacker's office to see what to do. And at that point, Mr. Stringer asked for a piece of paper to try and write down why he was going to leave the flash drive with us. And I told him I wasn't going to do that yet, that he could just have a seat. I needed to go ask some questions before I accept anything from him. So, like I stated, Miss Brooks was not in her office, who is my boss. Our Chief Deputy Clerk, Sherry Smith, was not in her office, who is next down from Miss Brooks. I tried to come in here. Judge Thacker was not here. And then I went upstairs and spoke with Judge Shepard and explained the situation. And we looked into Mr. Stringer's case, and he explained to me that at that moment, Mr. Stringer had filed an injury of appearance trying to represent himself, and Singleton Firm had filed a withdrawal of motion or withdrawal of counsel, but that order withdrawing them from the case had not been signed. So I came back into the office. At that point, Mr. Stringer was not in there. He came in probably 30 seconds after and had a piece of paper in the flash drive and tried to hand it to me, and I didn't take it. And I explained to him that at that point he was still represented by counsel. We cannot accept anything over the counter. It has to be electronically filed, and that he can't file anything pro se because at that moment, he still had an attorney. He still had representation. And he went back and forth that I was going to take it. And I'd explained to him multiple times that I was not going to take it. We could not take it. He can't file anything pro se. He still has an attorney. And he asked about trying to give it to the Singleton firm. And I said that was up to them whether or not they wanted to file it. I have no control over that. And he didn't exactly like those answers. And I told him that he could either try to come back Monday and speak with our Superior Court clerk, Miss Brooks, or try and speak with the Singleton firm and see if they would file it. To which he replied something along the lines of, it's an hour and a half to an hour, 45-minute drive for him, and that would be an inconvenience for him. And I just told him I wasn't going to argue with him, that he could come back Monday and speak with our clerk, or he could try to work with the Singleton firm, but we could not accept the filing at that point. And to which he pushed it through the clerk's office window. We do have glass, but there's a window where we can slide things back and forth, and said, well, I'm going to leave this here with you and file it. And then he turned around and walked out. So I picked up the flash drive and the piece of paper that he was trying to file, went outside, and Mr. Stringer was trying to exit, and I caught Piper and got Piper's attention and explained the whole situation to him. Piper took the piece of paper Mr. Stringer had written on, as well as the flash drive, and put it into the sheriff's safe up front.
So based on your experience as a clerk of the court, was your normal process interrupted?
Yes.
Was your normal process interfered with?
Yes.
Did you repeatedly explain to Mr. Stringer that you would not accept the filing?
Multiple times.
I do not want to hold your feet to the fire, but was it more than twice?
Yes.
Did anyone in the clerk's office observe this?
There were a few people that were absent that day, but I would say at least 10 of our other clerks were in there watching behind the scenes, and it was enough to draw their attention to the counter, which generally doesn't happen because we have people pass through there daily for numerous reasons, but everyone.
Hey, thank you so much for the super chat. I appreciate it. Tried to sneak in late, but couldn't. You know what? I'm glad you're here. I am glad you're here. Thank you for the super chat. Yeah. Also, someone working at a court counter as a court clerk or whatever her title is, you can't say that you don't have upset people there. You know, if not a daily basis, a couple times a week. Yeah, is it going to disrupt the court process when someone's there that's upset? Yeah, yeah. People aren't happy when they're in court. I, I, I think this is a stretch. Just because someone's upset doesn't mean that they're disrupting your process. I mean, yeah, someone talking to you, even being really happy and talking your ear off for 5 minutes about something unrelated is disrupting your process. You can go either way with emotion. Come on, prosecutor, you gotta get down to it.
At that point was their attention was towards the counter.
Is this something which has occurred on a regular basis? Someone confronting a clerk regarding a filing?
Not in my experience of being in there now.
In your experience, did any of the words you used or any of the explanations you used or any of the reasons that you gave Mr. Stringer, would they be termed as confusing or not being able to understand what was said to him?
No, I explained myself multiple times and repeated myself multiple times with the same scenario, that he could either come back Monday and speak with our clerk, Miss Debbie Brooks, or he could try to work with a Singleton law firm, but that we could not accept it because he was not pro se at that point, and he still had representation. And furthermore, that we could not accept anything over the counter. It all has to be electronically filed.
And based on your experience, did you consider this exchange disruptive?
Yes.
Were you aware at the time that you were being recorded?
I was not.
Is it your opinion that someone has to be loud to be rude?
No.
Is it your opinion that someone has to be loud to be aggressive?
No.
Is it your opinion that someone has to be loud to be disruptive?
No.
And you were simply following a written order by the court and orders by a judge,
That's correct.
that being Patrick Shepard.
That's correct.
I believe that's all I have, Your Honor.
All right.
Am I allowed to object on
What's your objection?
hearsay, whether something is?
Yeah, you're not using the mic. I'm not hearing you either, so.
Yeah, am I allowed to object on hearsay for, saying,
State your objection.
objective on the?
You're
fact-
allowed to state any objection.
Yes,
and
sir.
My responsibility is to rule on that objection as it's given to me. So
Yes, Your Honor.
if you have an objection, state it, and then I will rule on it.
Yes, Your Honor. Objection to, saying, to the opinion of, someone being, loud or whatever and, being is disruptive or, what she was saying.
Okay.
Yeah, it's not a legal objection. I see what he's saying. He's kind of saying the same thing I did. You're saying that that he was in contempt. He's in contempt of court for messing up your day and being disruptive because he tried to turn in a thumbnail and then he was visibly upset and walked away. Ask the question. Ask the question. Hopefully you worded it well enough because I want you to word it the way that I just asked because I want to hear what the judge says.
All right. Anything else to that objection?
No, Your Honor.
All right. That objection. Ms. Sexton, have you
Dang
finished?
I believe I have, Your Honor.
Okay. All right. So, Mr.
Yeah, it's not a legal objection, but it's a fair point. But it's for cross examination. So you better ask her that now. It's a really good question. So is it disruptive if someone's really in a really good mood and just chats away to you, and the next thing you know, 10 minutes are gone? Is that disruptive to your day? I'm not defending this guy at all. We're about to hear the audio because he recorded it and he brought it as evidence. So we're gonna hear the audio. He's a dick, but it is worth noting that the prosecution's case is saying you were mean to me, you were mean to her. Let's hold him in contempt. You illegally recorded him. Okay, all right, he did that. Well, it wasn't illegal. They've already stated it wasn't illegal. It was in bad form. So right now they don't really have a case except he's disruptive, which is fine. You can hold someone in contempt for being disruptive, but yeah, the prosecutor's case is really weak in this contempt. At least that's my opinion.
Stringer, you may ask questions at this time. And whenever you're ready, we'll play this video. If you've got it pulled up.
Yes, Your Honor. It's the audio. I had the audio pulled up and.
Oh, I said video. I'm so sorry.
right.
You said audio and I should have said audio back.
Yes, Your Honor. All right. Actually, let me see. I can bring my notes with me.
There is not a week that goes by that I do not quote that line right there. Bill, good to see you tonight.
All right. So before you get started, I'll just say again, nice and slow and loud and clear so that Ms. Scandy can make a good record of this.
Yes, Your
All
Honor.
right. Go ahead.
You said your name is Carly. Is that correct?
Yes.
Miss Carly, you said that you did see me on May 1st.
That's fine.
I think it was around. Let's see if I can find that if I have the time down somewhere.
Yeah, there is an hour more. At this point, I was going to ask you guys if you wanted to continue. The end of this is what's the best. The very end is so good that I had to play the entire thing. And I said in the intro, I'm so sorry for all the pain. I really am. But we got to go through all this to get to the juicy part. And it's I think the last 10 minutes of this video. But it's up to you guys. Do you want to split this into 2 videos? You want to finish it tomorrow night? Or do you want to keep playing it tonight? I will start a poll. We will do it. We will do a poll and see what you guys want to do. Also, MB, thank you so much for the PayPal. And you're welcome. MB said thank you for the pain. So yeah, you're welcome. All right, I'm gonna start a poll. If you want to finish this tomorrow night, we'll finish it tomorrow night. If you want to finish, if you want to keep it going, we'll keep it going. But like I said, the last 10 minutes of this video is the only reason why I'm playing this 2 hour long video. just we just we gotta get through the vegetables first. All right. Yeah, poll. Let's go.
I did come in and I did state that I had, upon our initial reading or initial interaction, I said that I wanted to file the document. I just had the flash drive, and you said, is it correct that you said that you weren't quite sure if I could file it or not, and that you had to go figure out if you could?
That's correct. I asked you to have a seat because I wasn't sure that we were able to accept that at the counter because we are e-file court only and we don't accept flash drives at the counter.
Okay, yeah, and I said I will be right back. Do you remember me saying I will be right back so I could, write something down just to help clarify things if that helps? And you said, yeah, that's fine.
Yes.
Okay, and then when I first I had asked you for the pen, and then I went upstairs to the library to go grab it and kind of wrote it down in the library, and then came back and went to go turn it into you.
I mean, I can do that too. You know what? Maybe that's what we do. I mean, we pretty much have another 45 minutes of this. Maybe that's hold on. I will change the poll. Finish tonight, and I'll you know what? I'm going to change it because I think that actually makes sense. I think we've heard everything we need to hear about this case. He's going to ask the same question she just did, the prosecutor did. You know what? Let's do that.
Do you remember me? Do you remember me saying when I asked you that you had denied it, and then I had said that I'm not allowed to file it? Do you remember me? You had said that, right? That I'm not allowed to file it.
I remember telling you that we could not accept it at the time because you were still you were still represented by an attorney, so you could not file anything pro se.
Yes, and I had told you I had already filed it and it had been accepted, saying that I was bringing in the flash drive the next day.
I do recall you saying that you filed something the day prior, which was an entry of appearance saying that you wanted to represent yourself and that you ordered Singleton's office to file a withdrawal of counsel, but
do you remember me saying that I had filed something saying that I was gonna filed something saying that I was gonna bring it in already and that it had already been accepted?
I think that was included on the entry of appearance, but just because that's stated on there does not mean that we can accept it at the counter. We can accept the entry of appearance and the motions that were attached to it, but just because you said something on there stating that you were going to file the flash drive or the USB with us does not mean that we have to take it at the counter, because that was not electronically filing it.
And did you ever tell me that? Did you ever tell me? No, Miss.
All right. If skip to the last 10 minutes is, if that's the winner, I will play the audio because they do play it. We're about 20 minutes away from that, but I'll play that, then I'll skip to the end if that's the winner. But I'm gonna give it about 5 minutes before I look at the poll again.
Is it okay if I grab this?
Yes.
Miss Sexton had given me the second amended order mandating certain case types to electric filing status. And this is something pretty much saying that I couldn't file flash drives anymore. Did you show me this or tell me that you guys had this?
At the counter now.
Okay. And just want to clarify, are you a judge?
No,
Have you ever practiced to be a judge?
I have not.
And you work at you're the clerk at the counter, correct?
That's correct.
And you accept filings?
Electronically, yes.
Yes. Have you ever accepted filings electronically that weren't ruled upon that said day?
Don't understand what you're asking.
Has someone ever filed something electronically and they didn't have it ordered by the judge that same day? Like have it signed by the judge that same day?
No, if anything, like if we get a motion or a bench warrant lift or anything that comes through our e-file system, we're responsible for checking it, making sure that the solicitor's signature is on there, the judge's signature is on there. So if it's not signed, we're able to reject it through our system.
Yes.
Yeah, but you're asking the wrong question. And the clerk kind of hinted at that. If you're filing a motion, it's not going to have the judge's signature, the prosecutor's. It's not going to have. You can file motions electronically. You just have to have it in enough days in advance, and you have to follow the right protocol. You can't just show up with a thumb drive when they're not accepting thumb drives. So ask the right question, man. Yeah, this guy's not dumb. He's just not the nicest person.
But have you ever had filings like that for the judge that weren't ordered upon on that same day?
If you're referring to the withdrawal of counsel, yes.
Well, and not just that. I'm talking about in general with other filings as well.
Objection, non-responsive. Come on, guy. I don't want to do your job for you, man. This is not my case.
To my knowledge, the only thing that would have to have a signature afterwards would be the withdrawal of counsel or the order granting the withdrawal of counsel. So
Objection, non-responsive. Ask your question again. She's not answering it.
Are you saying that the withdrawal of counsel is the only document that you've ever had that was not ordered upon that day?
I don't.
To try to clarify, so if someone files something, does the judge always sign it that day?
Yes.
If I filed an order of withdrawal, he would either sign it that day or not sign it at all.
For withdrawal, they're not always signed the day of, but anything as far as like a bench warrant lift, a null pros, everything.
What he's trying to get the court clerk to admit to is that people do file motions and submit evidence that aren't signed by the judge. That's what he's trying to get her to answer. He's not asking it in the right way, but also I feel like she's making her own answer up. He didn't say anything about a withdrawal. He said, "Does anyone ever file anything that's not signed by the judge?" And she's like, "Oh, you mean a withdrawal?" No. So I don't know. Was it a really bad question, or is the court clerk acting dumb here? Or are they both dumb? I don't know. But yeah, I understand where he's going with these questions, and it makes sense for what the underlying charge of him being held in contempt. He's asking good questions right now. He needs to get her to answer them. That's the problem here, and she's completely avoiding them, and I don't know why. So I get what he's asking. He can do a little bit better at asking, but they're not bad questions.
A final disposition, anything like that is signed by the judge the day of.
So you're saying not everything is signed by the judge the day of. Is that correct?
If you're talking about the withdrawal, that doesn't have to have a judge's signature. The order granting the withdrawal has to have the judge's signature.
Yes, but what I'm saying is not everything. If I file a withdrawal today, it's not necessarily signed today. It might be signed at a later date.
The withdrawal would not be signed by the judge.
Exactly. Oh, okay. So, with that.
Yes, Shava, you are correct. You are absolutely correct. She also could not accept the thumb drive. All of those are true, but we're getting to the point why he's held in contempt. For him, recording illegally because he was upset that they wouldn't accept anything. So I think it's very important for him to lay the basis down for why he got frustrated. So he's representing himself right now, and this is important. You're trying to defend yourself against contempt of court.
And I also did state that it took me about an hour and a half, 2-hour drive to get there that day, and that I couldn't. You say come back Monday, and I said I couldn't come back Monday because of the amount that it costs to go back and forth every single time. Is that correct?
Yes.
did you know that it is according to the law that it is not upon the clerk to make a judgment, but it's upon the judge to make the judgment?
The judgment for what?
As far as like as far as whether something is ruled in favor.
No, absolutely not. I've called this guy a jerk. I think I called him an asshole earlier. I know I've called him a dick at least once, but he has the right to defend himself, and he's doing that. So the clerk needs to answer the question. That's all. That's my only point. I can see where his line of question is going, and I want the clerk to answer the question just so he has a fair shake at this. I am not a fan of this guy whatsoever. Yeah, I'll stop there.
Of or not, like if you wouldn't be the one to sign the withdrawal order, it would be the judge, correct?
That's correct.
Okay.
I'm not a judge.
So it's so is it possible that something like if I was to file an exhibit, it might not get necessarily signed that day, it might get signed at a different day?
An exhibit doesn't have to be signed by the judge.
Okay. So so then at that point we know that although it could be filed, it could be denied by the judge at a different day, or you're saying an exhibit wouldn't be denied at all. Is that what you're saying?
I don't understand what you're asking.
So you're when I said that following an exhibit, that it wouldn't get. You said it doesn't need a signature, correct?
Yes, if you're talking about like an entry appearance, motions, exhibits, the exhibits attached to the motions that you filed do not have to have a signature by the judge. That's correct.
Okay. Okay. And so then moving on from there, on the, if you could give me one moment. On the, as far as the indirect contempt and bond status review hearing, it says on or about May 1st, 2026, the defendant, Mr. Stringer, while represented by counsel, entered the office of the clerk of the state, the court, and admitted to submit a personal electronic storage device containing alleged advice for filing. Are you saying that everything on here was true?
I don't know. I did not file that order.
Can I give her an exhibit for her to take a look at and determine?
I mean, you're welcome to. I'm telling, I've already put on the record that I wrote that.
Oh, okay.
I wrote those words.
Okay, I apologize.
And that's okay, but I wrote those words after getting just enough information
Okay.
for me to know I needed to have a hearing on it.
Okay.
So you're welcome to ask her about the difference between her perception of it and mine, but I'm just telling you right now, I don't care.
Yes, sir.
Because again, whatever the evidence is today is what will control. That's just more of the charging document.
Yeah.
So, but you're welcome to ask her. You're welcome to show it to her, and you're welcome to ask it. Don't let me stop you. I'm just telling you, that's not of that much consideration for me.
Yeah.
All right. What does the poll say? Skip to the end. I think that was Jedi's way of saying finish this now. All right. Let's find the poll. Hold on. I'm going to play it I'm going to pull this video up separately just to get the timestamp of the audio of what he recorded. So hold on.
So,
and I said it's a charging document, but that's not it. It's a notice pleading, for lack of a better term. It's just to get it to you that, hey, there's something we need to sort out here.
Yes, sir.
Okay. I just realized calling it a charging document was the wrong term and it set the wrong standard. Go ahead.
I appreciate that. Okay.
Again, you're welcome to ask her about it.
Yeah. I just didn't know she had wrote it, and I just wanted to get clarification. Just, if
No,
what
I
was
wrote-
put on it.
I wrote every
Yeah,
word of that
yeah, yeah.
document
Okay.
myself.
But moving forward, so now you say going back to where we were, we kind of went back and forth. Did you make it very clear that the court does not accept flash drives to me when you stated everything?
From my recollection, yes, I made it very clear that you still had an attorney at,
All right, we're about 15 minutes away from the audio clip. I'll fast forward.
Give me the email address to send it to. So if she never received it at that email address, I want to make sure that I do get the right email address.
Okay,
And that
well,
we
y'all can
could
do that after court today.
Okay. And just as far as the other thing, if I'm able to submit this, can I also submit the other video that I've been trying to
Yes.
submit as well? Okay.
Yeah, that's perfectly fine. We'll give it all to Terry.
Jedi, what do you call it when you have 1,000 Chrome windows open? I feel like you have a word for it, right?
And Terry will keep a copy. And that way this transcript will reflect all that. Again,
Okay.
that's the right way to do this.
Yes, Your Honor.
Okay. All right, go ahead and play your audio.
Okay.
How long is it?
It's only 4 minutes.
Okay, thank you.
Can you hear it? I think it's on.
No.
Can you hear it?
Hey, man. Wrote it up for you. Yeah.
Can everybody hear it?
So it looks like your insurance was filed yesterday. Let me get it right, lady. So Singleton's office did motion to withdraw.
Yeah.
Actually on the phone. The judge has not signed it, well, just removing it from your case.
Okay.
So you can't file anything pro se until they're officially off your case.
Okay.
So we can't take the USB until they're officially off your case.
Well, I'll leave it here until then.
Because you're trying to file that pro se, and technically, there hasn't been an order moving this from your case. We have to wait for the judge to sign that, and then we can accept pro se filing.
Either way, it goes with what they filed. They needed the video for the Brady's motion
So
as
if you want
well.
to give that to them before the order is filed, that's up to you, but right now, because we still have Singleton's office representing you, and the judge hasn't signed the order for the withdrawal of counsel, we cannot accept anything pro se.
I don't have any,
Yes.
but they've withdrawn as well.
They've withdrawn, but the judge has to sign an order removing order with this signature.
Yeah, but it's the last day to file everything.
We can't take it, if you're technically not pro se. They have not signed an order removing Singleton from your case. So we cannot take anything pro se.
So what if they file it?
If they file it, that's up to them. But we can't take it from you.
The blue one is for places like Stable.
Well, I could file it until it's signed.
No,
Yeah.
no, you can't.
Yeah, yeah.
You cannot. Not here, not with us, because you still have an attorney. You cannot file anything pro se while you have it.
But they even filed something saying that
I'm not
not the
gonna
attorney.
argue with you right now. If you wanna come back Monday and talk to our clerk, but we cannot take that.
Yeah, but I can't come back. It's an hour and a half to get back.
I don't know what to tell you. Our clerk is not here, and we still have your attorney listed as Dwayne Singleton's office. So you cannot file anything per se on your case while you have an attorney.
Okay, can I leave it
No,
here?
you cannot.
And then in the
No.
meantime,
No,
you can tell me if it's rejected or not?
no, if they wanna present that to us, if you wanna take that seriously, that's fine.
Well, I'm leaving it here. If you guys want to take it, you can. If not, that's fine.
Can you please, send me this?
What is it? Yeah. Oh, I gotta go that way. I bet.
Wait, not that. Because it's so much.
Thank you.
That's it, Your Honor.
All right. Was that the entirety of the audio from start to finish?
Yes, the end of it, there's a couple seconds left. That's just
All right, so that was the audio. It wasn't anything too exciting, really wasn't. But I'm gonna fast forward to the judge's ruling now. We really don't need to hear anything else. Hold on.
Every turn, he questions.
Oh, the prosecutor does kind of go into him though. Hold on. Here we go. This is the very end. Let's see, the very end of him, right before the prosecutor comes up, and then we get this is the fireworks at the end that I wanted to show you. All right, we pretty much heard everything. I know I fast forwarded about, I don't know, 30 minutes of it. Now, if you guys want to watch the entire thing, it's Spalding County Courthouse. It's in Georgia. It's Judge I can't think of his name. His name Thacker, Judge Thacker. So Judge Thacker, Spalding County, Georgia. You can go back and watch the entire thing. It happened, I think, last Thursday or Friday. You'll find it. If you want to watch what I fast forwarded through, it's painful though. He pretty much asked the same question 47 times. So yeah, I'm glad you guys voted to fast forward it. I probably should have just fast forwarded it myself. But all right, we're gonna finish this now. We got about 15 minutes left. So yeah, let me make sure I'm caught up on super chats. Did I thank Phil? Phil, I thanked you, right? I don't know if I thanked Phil. Phil, thank you so much for the 5 gifted memberships. Welcome to the 5 new members. Phil, I am so sorry if I missed you. I just looked and it wasn't grayed out. And when I click on it, it grays out and it wasn't. So if I missed you, I'm so sorry, bud. I'm so sorry. All right, let's go. We got about, like I said, we got about 15 minutes left.
perfect. It's not criminal contempt. Criminal contempt requires willfulness, a deliberate, specific intent to obstruct the court. That's OCGA 15-1-4, Tolbert State 290, Georgia Appellate 288 from 2008. The recordings show I was cooperative and calm. I was not willful. And because of this, I hope that you're able to find that, find those things to be true.
All right. Thank you. Ms. Sexton?
Thank you.
We're here on a indirect contempt charge. We're here on a status review of the modification of the bond. And I think why we really have to understand we're here is that despite Christopher Stringer's words, despite the defendant's words, the absolute essence of this case is a lack of respect. The absolute essence is a lack of respect. There was a lack of respect when dealing with Mr. Charles's office. There was a lack of respect when dealing with Mr. Singleton's office. And with all due respect, there is a total lack of respect dealing with the state in this case. Even in his closing, he is arguing that I have footage that I never turned over to him. The state never had one single slice, piece, molecule of evidence that we have not turned over. If Mr. Stringer, if the defendant is going to act pro se, having dismissed 2 of his attorneys, he is going to have to deal with the fact that it is incumbent upon him to know this system. It is not fair to expect him to say, I did not understand this. I did not know this. I was not told this. He had an excellent public defender. He chose to dismiss that public defender. He had an absolute excellent local law firm, and he decided on the eve of this situation to fire them. We are not responsible for those decisions. When he made those decisions, it's incumbent upon him to know how he has to work around that situation. This court should not give any deference to the fact that he is not an attorney. None whatsoever. He has chosen to walk away from 2 separate law firms. He has chosen to accuse the state of withholding evidence and has called it exculpatory evidence, which is the only reason that Baker would apply. And he stood in front of you and read AI pages and pages and pages. And you simply asked him, let me get this straight. Are you accusing the state of withholding evidence? And the answer was yes. The state has never withheld evidence. The state did not give him did not misrepresent the officer. And again, this is being stated. There is an incumbent lack of respect of this court that at every turn he questions. We have, quote, thrown blocks in his defense by not giving him, by misrepresenting who is out on FMLA. Never once did anybody ask me who that officer was. Instead, he was filing motions, and yet indeed is filing motions that continuance was not proper. His information has given the state and this court no benefit of the doubt. At every turn, this office has been accused of malfeasance. And it's about time that he is not excused for being pro se. It was his choice to walk away from that firm on the eve of that filing. And by the way, that filing, there was no hard deadline for that. There's a reference. Let's put this in perspective. There was a hearing, and you said, I have no information that I have no information that the state is withholding evidence. No information. If you have any information that the state's withholding evidence, we'll rehear it. There was no information the state was withholding evidence. And yet here we go again. The motions are filed and refiled and refiled. The state is busy. The court is busy. I'm tired of being accused of lying. The state is tired.
Oh man, you need to stop taking this personal. Especially when the guy who's being accused of being a jerk, being held in contempt, well, he's at a hearing for contempt, and you're the one who's yelling, and he's been calm the entire time. I mean, I get it, but she's taking this way too personal. Dare I say she needs to calm down? I know you don't tell a lady to do that, but I feel like maybe she needs to sit down and take a breath.
The state is tired. At every corner, I have been accused. There is a transcript which states that the defendant knows that his attorney handed over that documentation, that hard drive to me. There's an insinuation that I had that hard drive, but I'm not letting you see it. That is never the case, Your Honor. And then on this day in question, on this particular day in question, this man walks in, and while it may not be illegal, it is really bad form to record the clerk's office. And by the way, we have no information and no recording about how Carly handled that before she went up and tried to find somebody to help her and talk to Patrick Shepard. Carly went above and beyond to try to figure out if she could help him. Above and beyond. She tried to find you, she tried to find the head clerk, she tried to find all these people. She ran up and she talked to Patrick. As we've established, she's not a judge. She talked to a judge. She went above and beyond, and yet, at the end of the day, whether it was shoving, gently placing, maneuvering, whatever verb you want to use, that evidence left his hands and got sent through a window, which is a protective window that protects our clerks from the public, and things don't go through that window without the clerk reaching for it and accepting it. There is absolutely 100% evidence that has been presented in this court that he was aware that he could not file it, that he was told repeatedly he could not file it, and that
Wait, what does that make me? What does that make me? Come on, Sandy. Come on.
he disrupted the process of that clerk's office to the point that all of the clerks sat and watched this. Carly's been a clerk for a long time. This has never happened to her before. She's under orders not to accept an e-filing. She's not under orders. As a matter of fact, she's under express orders not to give legal advice. She is not allowed to give legal advice. This is a pitfall of dismissing your attorney because your attorney will not go after the state for an FMLA situation, which was incorrect. If Mr. Stringer wants to represent himself, then he is held to the code of an attorney who knows the rules of the court, the ethics of the court, the processes of the court. And he violated those processes and he disrupted them. Therefore, the state asks that the court finds that Mr. Stringer is guilty of contempt, of indirect contempt. And in the alternative, the state is requesting that the bond status be reviewed and revoked.
All right, thank you. Okay.
Your Honor, I don't know.
Okay. We're done. I
That's what I was asking.
I gave you your hearing. It's my turn.
All right. That was good. I told you. We'll get some fireworks at the end. Now wait for the judge. Judge isn't happy either. So what the judge is about to say is why I've been calling this guy a jerk all night. Because I do believe the judge. I think the prosecutor is a little too she's too invested in this case. She's upset because she has to work a little extra on it. With most pro ses, you're gonna have to work a little harder because especially if they're actually trying to defend themselves and filing motions, it's gonna be a mess. But so she's a little too invested. That's how. Notice how I changed it. Words are hard. Instead of saying she's too emotional or she needs to calm down, she's too invested. She's too invested. She's take a back seat for a minute. Listen to what the judge says. This is my favorite part of this entire hearing.
That's exactly what I was asking. Yes,
Yep. Glad you asked it because we're going to clear that up because I don't want you to interrupt me while I'm doing my part.
Yes, sir.
All right. The evidence as I've heard it is that Mr. Stringer personally appeared in the clerk's office. I believe it would have been the 1st of May which is the day after his attorneys filed a motion to withdraw to file. And he also electronically filed paperwork with the court clerk that he wanted to represent himself. I had not yet signed the order yet because those gears had not made it to me. And frankly, I think I was out of the office that day. And so when I got back, I have had to deal with this issue extensively. And I should not be dealing with this issue.
Yes, Your Honor.
I granted your speedy trial demand. I have put the state on alert that they will try this case in August or I will dismiss it in September. You got what you needed out of me. And in return, you said about me not allowing you to put it into evidence that day. That was not the time for that video to be placed into evidence. This is not the time to be placed into evidence. I'm just doing it because I'm tired of talking about it and you desperately want me to watch it. And so I'm going to let you put it in. But my point is that I have had to spend,
Judge DeSanto had one okay hearing and one good hearing. OSG played the good hearing. I played the okay hearing. Yeah, sorry. I put out 2 videos a day and do 1 live stream. Yeah, you don't have to be here. You really don't. You can go to OSG's channel and watch the video that you want to watch with no commentary and no chat. I'm not going to be disappointed. You can choose what you want to watch, but don't tell me that I'm disappointing you because you're not a fan of the videos I choose. I do this all day, right? I watch court for 12 hours a day. I'm not going to let you sit there and tell me that I disappoint you. Like, yeah, great, awesome. You're not gonna ruin my night. You absolutely aren't. So yeah, go watch it again on OSG's channel, and or you can come back tomorrow night when I play it tomorrow night, or release it as a video tomorrow. I already said I would because it was a good video, but I already had my night planned. Sorry.
hours dealing with this issue,
Yes, Your Honor.
which is utterly unacceptable. Because your audio, you think it helped you, it hurt you. I heard you very clearly on that audio say, well, I'm leaving it here. And then today you said that you had no other options. And you have chosen to represent yourself after letting and Ms. Sexton was correct about this. You had, frankly, the best public defender in the state of Georgia representing you in this courtroom. Harry Charles was the capital defender before he retired to come work for us as a hobby. He is a brilliant lawyer and knows exactly what he is doing and is a very effective attorney. So you had a brilliant public defender looking out for you. You fired him. You then brought a brilliant local defense attorney office in to represent you, which I made no secret from the bench. I was very pleased with because it meant that we didn't have to deal with you directly anymore because frankly, your personality is a very strong personality and it can come across as abrasive.
I apologize.
And so I'm just saying out loud that you had a wonderful buffer between you and the court doing this. And you let them go and decide to represent yourself. The only reason I bring that out is so that you hear me say that I'm hearing very clearly that you want it both ways. You want to both represent yourself and talk about how you don't understand how it works and you're confused and you don't know what to do. Well, the fact is that if you're going to represent yourself, I'm going to hold you to the same standard I would hold any lawyer that was sitting at that table. And I'm not going to put up with your shenanigans and nonsense and anything else anymore. You are going to operate at the level of professionalism, the level of respect, and you are going to listen to the directions that this team is giving you, and you will follow those directions.
Sure.
And none of those directions are going to keep you from advocating fully and loudly as best as you can in your defense.
Sure.
But the next time I hear so much of a peep about you causing any noise, I'm going to revoke your bond in full and we're going to be done.
Yes, Your Honor.
Am I being extraordinarily clear about the razor's edge you are standing on with me?
Yes, Your Honor.
Because I clearly heard Carly Evans tell you very clear instructions that I had no trouble understanding. And your response, and I wrote it down from your audio, was, well, I'm leaving it here. And you left it there, and I heard her calling after you while you were leaving. Mr. Stringer, Mr. Stringer. I heard her calling, and you ignored her. Now, you may say you didn't hear, but I don't care what you think. I'm telling you what I heard, and I'm telling you what my conclusion is.
Yes, Your Honor.
I'm telling you that your actions that day have taken up countless hours of my life dealing with this issue when we should all be getting ready for trial.
Yes, Your Honor.
Okay? So, is there enough for me to find beyond a reasonable doubt that you have committed the offense of indirect contempt by disrupting the clerk's office. That standard is beyond a reasonable doubt. I find that for that standard, the answer is no. I do find fully that by preponderance of the evidence, your actions have severely disrupted the operations of this court. I am so.
I agree with him. I agree 100%. Contempt of court, I think that would have been a stretch, but yeah, he disrupted the court that day. So judge is about to do what he's going to do. Yeah, I didn't want to see this guy going to jail over this. But yeah, I love that the judge is smacking him down right now. He really is. So good on you, judge. I really do like this judge. I'm gonna let the rest of the video play out. I've gone for long enough. There's about a minute and a half, 2 minutes left. Dude's about to get kicked out of court. I'm just gonna tell you how that judge is like, get out of here now before I put you in jail. You guys are awesome. Thank you so much for watching. I do have a couple of super chats real quick to catch up with. Abby's disappointment dollars. I like it. Don't give Abby too much. I should not have said what I said. Um, More than just defending myself. I shouldn't have attacked her. I think it was her that left a comment in a video today saying, "I hope you play this tonight," and I responded saying, "I'm not. I'll play it tomorrow." It may not have been her. I think it was though. So she already knew I wasn't playing it tonight. So I think that's where a little bit of my, you know, frustration came from. But it's okay. MB though, thank you so much for the super chat. Alan, thank you so much for the 5 gifted memberships. Welcome to the 5 new members. Thank you so much, Alan and Sandy. Good, thank you so much, Sandy. I love it here, Colin. I tease you, but it's love. Well, I love that you love it here. I love that you love it here. Yeah, all right. Thank you so much for the super chat, Sandy. I appreciate it. Okay, that's it. I'm gonna let the rest of the video play out. You guys are awesome. Thank you guys so much for the super chat, skip the membership milestones, mods. You are awesome. Thank you so much for your hard work. Have a great rest of your evening. Tomorrow night is yoga night, so we will be live at 7 instead of 8. So I'll see you then. Goodbye.
Frustrated right now that you don't want me to make this decision from the bench. You want me to take a little time and calm down. Because if I make this decision right now, Cersei's going to put handcuffs on you and you're going to go to the jail till I calm down. So instead, we're going to do this. We are going to wrap up this hearing. You are going to quietly pack up your stuff, respect.
Yeah. Yes, there was a lot of good court out there. Here's the thing. I do my best to play things that other people aren't playing. So when OSG played that video this afternoon, I wasn't going to play it tonight. I was going to save this video for the weekend, but OSG played it. So that's why I decided not to play it tonight. When I play videos that everyone's seen, my viewerships are down. I have over 200 people here tonight. This is the best night I've had in 2 weeks. So I am not disappointed with how it showed up. I'm sorry you're disappointed that you didn't think that this was the best video that I could have played. Here's the thing. I got to do what's best for my channel, and that's just it. So playing a video that everyone else has played, not the best idea. If I wait till tomorrow and, half the crowd hasn't seen it, it's better. I could put it into a live tomorrow night. This is what goes through my head. Welcome to being a YouTuber.
Get your bag together and quietly leave this courthouse.
That's right.
You are going to send that Google Drive link with these videos on it to myself. I've given you my email address. You've already got Ms. Sexton's Gmail address. And I will review those again before I make a decision. But you're going to get an order from me that is going to significantly change your bond conditions. Because I no longer have faith in you that you are going to interact with this team in a way that is respectful and professional and courteous and all of the things that you have every right to expect from us to you.
That's right.
And I don't think it's fair for me to ask my team to extend those to you when you have shown a very clear pattern of not extending those to us. So the answer to the question is no, I don't find that I do not find you in indirect criminal contempt. So those 20 days are off the table. but I do find that you have absolutely disrupted the orderly operations of this court. And I do have the absolute right to modify your bond conditions, and I will be modifying your bond conditions. I may revoke your bond conditions, but I'm going to take a moment and breathe before I do that because you would want me to do that.
Yes, Your Honor.
Any questions before you go?
No, Your Honor.
Okay, you want to put anything else on the record before we part ways?
No, Your Honor.
Okay, anything else, Ms. Sexton? Okay. You need to get those videos to me by tomorrow at 5. It's Thursday after lunch. Hopefully you can get them to me today. And I expect to give you my decision pretty soon.
And I have your email. Is it okay if I ask Ms. Sexton for her email?
Yeah, y'all can do that off
Okay.
record. So anything else?
That's it, Your Honor.
Okay. All right, that's our last hearing. Issue the warrants, forfeit the cash bonds. Anything else?